Appearing on behalf of the petition, the needful will be done. The consignment is not being found. The needful will be done and it will be sent again. Here,
Line counsel submitted the process in the course of the list of service offenders. Next.
Sachin CND.
Yes, Mr. Counsel.
Your Lordship, the counsel submission regarding the all the counsels who are in the wakalat make this sign, Your Lordship. Due to urgency, all the counsels are not signed, Your Lordship. Kindly accept my my sign in the wakalat, Your Lordship.
And that kind of a submission will be there.
Yes, Your
What
Lordship.
has to be followed has to be followed. Office
Your
objection.
Lordship, what we will file the
Office objections are sustained. Yes, next. The petitioner shall comply with the office objections. Yes, next.
Number 6. Can we hear about?
Today you have filed. What is, take the name? Land counsel so and so submits that. Land counsel so and so submits that he has already filed. He has filed wakalat today. Land counsel the petitioner to serve the copy of the petition to the counsel for the respondent. This matter on 29th. Intermodal is there. If the intermodal is there, extend. Yes, next. Huh? First. You want it on first? 9th. 9th December. Yes. Though notice is served on the respondents, no wakalat is filed on their behalf. I number 1 of 2024 is filed to condone the delay of 250 days in filing the petition. Considering the reasons stated, the delay is condoned. List this matter for preliminary hearing on 25th. Yes, next. Notice to respond. Notice to the respondents.
Lord, I will take out notice because there was order of dishonorable court which is violated by the executive court. So the counsel appearing before MFA and take out notice. In addition to that, I will serve it. Permit to take out notice to the counsel who appeared in the.
What is that MFA pending?
Lord, MFA announcement was there and they deposited. The executive court and the officials say it is not an announcement, it is only a sum of 20,000, which was differentiated. In fact, 1,65,000 was the announcement.
So between the same parties, MFA is pending.
No, it was disposed of. Execution filed by law.
No, you say that you will take the. How
yes,
can
sir,
it
the
be?
counsel who appeared in the MFA.
If it is pending, we can understand. In a disposed matter, you cannot. The
take out notice. Full rest.
On the respondent, you cannot. The process.
Please.
The registry is directed to issue emergent notice to the respondents. Yes, next. No representation on behalf of the counsel for the petitioner. Counsel for the respondent is present. This is matter for dismissal on 27th. Next.
Pass out. Kindly pass out.
No pass out today. This is matter on 28th. Yes, 8th. Yes, at the request of non-counsel. Notice. No representation for the petitioner. Counsel for the respondent is present for dismissal on 28th. Next.
There is a delay of 67 days in filing the petition also.
You filed objection? I number 1 of 2024 is filed to condone the delay of 667 days in filing the petition. No objections are filed by the respondent. However, when counsel for the respondent submits that the delay is an inordinate delay and the same cannot be condoned accordingly, now considering the reasons stated in the accompanying affidavit, the delay of 667 days is condoned on the condition that the petitioner shall pay an amount of rupees 2,000 as cost to the respondent within a period of 4 weeks from. No, that we will hear. No, interim order.
Please note that.
Interim order is there.
Please note, interim order.
Have you complied with the interim order?
Deposited before trial court. Receipt not yet received. Phrase one.
Then no, don't condone the delay. Let it keep it. List this matter on 20th. By the time you have to place that
Please.
what as per the interim order whether you are deposited or not. Then we will condone the delay.
Please.
13 on 20th. Yes, next.
Party, MB party.
There is no representation on behalf of the petitioner on 8/11/2024, and on the counsel for the respondent is present. This court had directed the matter to be listed today on the caption for dismissal. Today also there is no representation. This petition of 2023. And it appears that the petition is not interested to pursue the matter. Accordingly, dismissed for non-prosecution. Yes, next.
Bill number 50. Another Sandrigani.
Please, sorry, last petition I did not appear.
Yes.
This is a petition filed by the wife. In 125 proceedings were rejected on the ground that she is having sufficient income, madam.
Let's
In
see.
the divorce petition, madam,
Let's see the order.
please.
Read from the reasons.
Please. The petitioner number 1 got examined as PW1 and she deposited that her marriage with the respondent number 1 of Solomon 22/11/2010. The marriage card is at Exhibit P1. There is no dispute about the marriage and the birth of the child. The bona fide certificate of the petitioner number 2 is produced. Exhibit P2 which shows that he born on 6/10/2012. PW1 further deposes that her marriage was performed by her parents by spending 15 lakh rupees and giving 15 tolas of gold and cash of 100. They said that this is false because as per her own contention in para number 5 of her petition, she has stated under ಒಂದನೇ ಅರ್ಜಿದಾರರು ತವರು ಮನೆಯವರು ತುಂಬಾ ಬಡವರು ಇದ್ದು ಕೂಲಿ ಕೆಲಸ ಮಾಡಿಕೊಂಡು ತಮ್ಮ ಉಪಜೀವನವನ್ನು ನಡೆಸುತ್ತಿದ್ದು ಈ ಅರ್ಜಿದಾರರನ್ನು ನೋಡಿಕೊಳ್ಳುವುದು ತುಂಬಾ ದುಸ್ತರವಾಗಿರುತ್ತದೆ. When the parents of the petitioner number 1 doing coolie work and they cannot afford to look after the petitioner number 1, how they can spend for the marriage? The PW1 further deposes that the respondent was looking after her with suspicious and he was checking her mobile.
Come to para 24. Para 24.
Yes, ma'am. It is the duty of the respondent to maintain his wife and child. In order to get the maintenance, the wife has to prove that there has been a negligence on the part of the husband. But here,
What is Exhibit R2?
R2, madam. R2 is the divorce petition filed by the wife, which came to be dismissed.
She has shown her income, which is marked as Exhibit R2 in MC number 104 of
My lord, where
2019.
records are there.
Take out what is this Exhibit R2.
That is the order passed in MC number 104 of 2019.
What is that exhibit R2?
R2 is the order passed in MC number one not
But as
four,
per this, it doesn't show so.
but ACID loan recovery, ACID loan recovery ಅಂತ. Income certificate.
Whose income certificate?
That is the income certificate of the petition.
Kumari Sujata. That is 5,000 per month. What is the husband's income?
He is the government servant, my lord. He is drawing more than 73,000 rupees salary.
21,145.
But as on today, my lord, his income.
Sum of deduction, we are looking at that. Sum of deductions and recoveries, so and so. Net salary, 21,145. What I'm not able to understand is court gives a finding that she has shown her income, which is marked as exhibit R2 in MC number. This is the one marked as MM.
Yes, ma'am.
Yes. What's your present income? Use the mic. No, he's drawing 21,000. No, there's a daughter also, daughter or son.
There's a son.
Two people have to manage themselves, maintain themselves.
Yes.
So why not some amount be granted to them without any basis? Just because it says that her annual income is 60,000. So how much it is per month? 5,000. How will two people live?
May I make the submission? Let's in the last date also in this MC itself that is marked as R2. It came to be dismissed. That is filed by the petitioners themselves. The direction was also given for them to lead a marital life. She has not joined the company of the respondent, nor it is challenged.
No, court can never compel them to live. What is the business of the court?
Indeed, please, madam.
If people are interested, then it will be done. Now, her income is 60,000. Yours is 2,40,000 and odd.
Look, this certificate that is marked as R2 Mullards has been issued in the year 2017.
No,
Now, my instructions, Mullards, is that, not mine, the income certificate of the petitioner. Now the instructions is that she has opened her own academy, Salon Academy, and is giving training to hundreds of people there. Now, based on that also, I sought for the documents of that also, Mullards. I have not yet received the photographs.
Counsel, the petitioner as well as the respondent shall file their statement of assets and liabilities as per the judgment of the Apex Court in Rashish vs. Neha. This is marked on 10th December.
I have one submission. At least for the son, my lord, some amount may be granted. I have filed interim application for maintenance.
Then what about son? Why it was not considered? You have a responsibility.
Please, insofar as son is concerned, no.
Then how much will pay?
That's 21,000 itself is there. I have my old experience and the land is along with
Pending
me.
consideration of this application, this court has observed that court had refused the case of the wife. As far as the son is concerned, there is no observation by the court. the husband shall pay 6,000 by 5th of every succeeding month. Yes, next.
Appear husband revision petition. 5,000 is award item.
Mm.
That's the respondent is a BA, respondent is a BA.
And you are?
BA respondent wise.
You are?
Let's I am a coolie. Initially, I was.
Up to the order.
Please. Initially, I was
Let's
running
look at the order.
Order at page number 9.
Come to para 12.
Please. Para number 12. May I read it? In view of the same, it is necessary to look into the oral evidence submitted by the both parties. During the course of the cross-examination to PW1, nothing but was elicited from the mouth of the petitioner. She has proposed that as she did not have money to attend the court at Kalburgi, she has not attended the same. However, new contention was stated by the petitioner to suggestion that she is not wearing Mangalasutra, and for this PW1 reports that Mangalasutra is taken away by her husband and hence she is not wearing the toy ring. This entire thing is not at all treated in the petition. Hence, it is well settled law that any amount of oral evidence without reading the same cannot be considered. Hence, the same cannot be considered. She also reports that she got to know about the decree of divorce as on the date of seeing the decree copy in the court. She reports that as her life is spoiled with the respondent, he is liable to pay her maintenance. It is admitted that she has not produced any document to show that earning capacity of the respondent, but deposed that he is capable to pay the maintenance to her. Admittedly, as on the date of this order, the marriage between the petitioner and respondent is dissolved with the decree of divorce. The respondent has shown to satisfaction of this court that he has made arrangement for the maintenance of his wife as on the date of petition. Further, the petitioner has deposed that the respondent willfully neglected her and refused to maintain her. This appears to be true by the conduct of the respondent. Though he appeared and cross-examined PW1 and filed his chief evidence and got examined as RW1, he did not appear before the court to tender himself for test of cross-examination. Hence, this court proceeded to discard the evidence of RW1. Hence, there is no hesitation to hold that the contention taken by the respondent, stating that he has not neglected the petitioner and has made every effort to get her back to his company, cannot be believed. Further, there is no document produced by him to prove the said contention, apart from getting the document of decree of divorce, getting marked by way of confrontation. Absolutely, there are no other documents produced by the respondent to disprove the case of the petitioner. On careful perusal of the awareness made in the objection filed by the respondent, it goes to show that it is not the case of the respondent that he is looking up to the petitioner by proving maintenance. From oral evidence of PW1, I have no hurdle to hold that the respondent has neglected and refused to maintain the petitioner as on the date of filing of this petition. It is pertinent to note that the contention taken up by the respondent in his objection remains as objection in a paper. The respondent failed to enter into witness box for test of cross-examination and prove his contention in spite of giving sufficient opportunities. Hence, his chief evidence is discarded. It is settled law that evidence include both chief and cross-examination. Near appearing for the chief examination and not appearing for the test of cross-examination will not assist the respondent to prove the contention taken by him in his objection. The petitioner has successfully proved before this court that the respondent has neglected and refused to maintain. Accordingly, I answer point number 1. Affirmative.
You have filed your statement of SSL liabilities before the
Please,
court.
minutes. What happened, minutes? Initially, I have filed the minutes in number 53 of 2021 for restitution of conjugal rights. That petition was allowed, and minutes respondent was directed to join the company of the present petitioner.
When was that?
Minutes, I have filed minutes. I have produced the NDC minutes. I have filed a memo on 8/11/2024 along with it. Para number 16 minutes. Very good.
MC number 341.
341. Minutes,
1/4/2022.
para number 15 minutes, the petitioner in
Thereafter you filed divorce.
they initially have filed a restitution of conjugal
No,
rights.
that I understood.
Please.
It is decreed.
Please.
Thereafter you filed MC for divorce.
Please, on the
What is
ground-
that MC number?
MC number 341/2021.
341
2021. I have produced our memo. Dated 8/11/2021.
What is the MC for restitution of conjugal rights?
That is MC number 53 of 2021. 50,
That is decreed on when?
decreed on minutes.
It is an ex parte order restitution of
Please,
conjugal
please.
rights.
18/9/2021. 18/9/2021.
No, both the orders are ex parte orders.
Please once. She did, even despite of service of notice, she did not appear before.
Please come. The present petition is filed. Agreed with the orders passed in criminal miscellaneous number 182 of 2021 dated 17 January 2023, whereby the wife is granted maintenance of an amount of Rs 5,000 per month. The respondent herein had filed the criminal miscellaneous seeking maintenance of an amount of Rs 20,000 per month. The court, by order imputed, had granted 5,000 to the wife. While granting the said maintenance, that there is no material on record to show that she has filed an appeal against the judgment, against the decree of divorce granted in MC number 341 of 2021. Further, the court observes that the said decree is passed after filing of this petition, and the respondent had not, the husband has not shown that he has made arrangement for her maintenance as on the date of filing of the petition, and it's a bounden duty of the husband to pay maintenance to the wife. And also observes that there is if an amount of Rs 20,000 is granted as maintenance, it would be on the higher side. The court in the interregnum had directed the husband to pay maintenance of 3,000 per month, but he had paid only 3,000 in the entire month. He has paid only once the 3,000. And the husband is not obeying the orders of the court. Considering the age of both the parties and the education qualification, and taking into consideration the present cost of living, the court felt that it's just and proper to direct the respondent to pay maintenance of Rs 5,000 per month, and it is not, and the husband will not be prejudiced in any manner. Next one. Agreed thereby, the husband is before this court. And counsel appearing for the husband submits that without a reasonable cause, wife is staying away from the matrimonial home, and in that regard, he has filed MC number 53 of 2021, seeking restitution of conjugal rights. Though notice was served, the wife had not appeared before the court, and that came to be decreed on 18/9/2021. Even after the said order passed by the court, when the wife had failed to join the husband, he had filed MC number 341 of 2021, seeking divorce. Even in that also, an ex parte decree was passed, and the divorce was granted by order dated 1/4/2022. He submits that in all the cases, in spite of receiving a notice, she has chosen not to appear. It is submitted that even before this court also, even after service of notice, she has not appeared before the court. And counsel submits that when all these circumstances show that without a reasonable cause, wife is staying away from the husband, and in such event, she is not entitled for maintenance. He submits that the wife is a B graduate and the husband is a coolie, and the court, without considering all these aspects, had granted maintenance of an amount of rupees 5,000. The same is contrary to law and is liable to be set aside. Next para. The notice is served on the respondent. No wakalat is filed on a behalf. Next para. Having heard the counsels on either side, there is a material on record. The undisputed facts are initially MC for restitution is filed, which came to be decreed ex parte. Then the husband, as the wife had not joined, has filed MC for divorce, that also decreed ex parte. A perusal of the order of the trial court reveals that, family court reveals that, the court had failed to consider these aspects. Further, the wife is more qualified, and according to the husband, is working as a coolie. The court has not even discussed about the financial capacity of the husband, nor about the wife. And just like that, an amount of rupees 5,000 is granted as maintenance. The court ought to have taken, the court should have taken into consideration the conduct of the wife, and also the conduct of the wife, comma, her educational qualification, comma, her refusal to join the husband, as such, which made him to file a petition for divorce. These are all the important factors which needs to be considered by the court before passing an order of maintenance. In the light of the above discussion, this court is of the considered opinion that the court had tried to consider the relevant factors and granted the maintenance. Hence, accordingly, this court is passing the following order. The RPFC is allowed by setting aside the order dated so and so, passed by so and so. Yes, next.
That's main. During the pendency of this case, the petitioner has deposited an amount of 35,000 and 49,000.
In the discussion, it is submitted that in his submissions, it is submitted that he has deposited an amount of rupees
35,000 and 49,000.
35,000 and 49,000 before this court. Now, in the penultimate, in the order portion, the petitioner is at the amount that is deposited before this court shall be returned to the petitioner.
Number 7, PSR. Shiva Suru.
Which was it, 2 days time.
This is matter on 21st November at the request of one counsel, the petitioner. Yes, next.
Number 8, unauthorized Pata.
Petition is the collective matter. The matter has been settled over.
Settled.
Please.
Then file a memo.
Please.
When will you file?
Kindly pass out. Council are appearing on the petition on another petition.
No pass out today. We'll have it on 20th. Learn council submits that the matter is settled between the parties and they'll come up with a necessary memo. List this matter on 22nd.
22 months. Not 22.
22nd.
Please.
Yes.
Bless.
Yes, next.
Number 9, Authorized.
Please.
Defendant petitions, my lord. I filed an application, my lord, for rejection of the bail, where my lordship has pointed out regarding the negative relief, as my lord section 34. Where my lord, I had produced even the plaint copy of translated plaint copy.
He sought for time, I think.
On that day, my lord,
I have sought for time for that to clarify the section 34 of specific relief act. Lord, my brother has filed a typed copy of the plaint in the translation in the English version. That before rejection, before come to the merit of the case, we go through the contents of the plaint, that whether the plaint is required to be considered or to be not rejected. My lord, the para 3, I will read it to be somehow take
Where
time.
is that page number?
Page number, the translated copy, my lord.
I tried a memo.
No, it must be there. On which day you have filed it?
On 13th level, yesterday.
Yes. You can read.
Please, my lord, para 3.
Yes.
The present suit, properties belong to property one lake on Narigalappa and son of Basappa Kabir of the Bahadur Bandi village. The property of Narigalappa Kabir died in the year 1954 in Bahadur Bandi village itself. The Narigalappa Kabir was having the 8 children. In that, 7 were sons and 1 daughter. The Narigalappa's 7 sons are Balappa so and 1 daughter named Siddhava, who is recently died. The present witness is a grandson of the Ravi Siddhappa, who is the 5th son of the Narigalappa Kabir. The present properties were cultivated by the late Narigalappa son of Basappa Kabir. After demise of Narigalappa Kabir, so properties were inherited in the name of the elder son Balappa as a joint family manager. The late Narigalappa was having around 105 acres of the land situated in the Badurbandi and Bihar. After demise of the late Narigalappa, all 7 sons were a partition of the family arrangement and cultivated the same. And the present suit of properties are inherited in the Balappa, who is the elder son of the Narigalappa. The present Balappa and his son Gaurava was not having any legal heirs. This is paramount. And the Balappa has died in the year 1983. And Gaurava, who was Balappa, died in the year 1992. In the Bahadur Bandi, the present suit properties and proposed late Narigalappa and his son Balappa was nowhere related to the present respondent number 1 and 4. Respondent 1 and 4 and mother and children. Fifth respondent has fraudulently taken the suit properties from the first respondent, entered his name. Sixth respondent was working as an employee in the revenue department and fraudulently he has entered in the first respondent's name in the government documents. The one Balappa, who is the elder son of late Narigalappa, was running a trading shop in APMC Koppal. Respondent 5 was working as a peon in the shop and present first respondent working as a cook in the late Balappa house. After demise of the Balappas, 1983, his wife Gaurav was looking after business recruiting in APMC through the help of the fifth respondent. Respondent 125 coming to know that late Balappa and his wife Gaurav was not having the legal heirs and taking the undue advantage of the Gaurava illiteracy by threatening her and colluding with the respondent 6. The entries in the documents were changed in the Balappa's module instead of Balappa Narigal, Kabir and others. The present respondent number 5, 1 to 5, 1 and 5.
What is this relief? I've seen the entire thing.
Yes. Here
your case is that they have the revenue entries are changed. In the year 1989, you give a complaint to the Tehsildar and you say that Tehsildar has not done anything. And you also keep quiet. One minute, you also keep quiet. Not this is a suit where you're seeking any directions or you made the Tehsildar as a party. That is also not the case. So entries as of now stands in their name. What is this declaration that they are not, you are saying it's a fraudulent transaction. If it is a fraudulent transaction, what you should say?
No, that I'm seeking the relief of that. They are the person who is claiming that legal rights, they are not at all belong to our family. They've been.
Then what the relief should be? That there is seeking a declaration that you are owner of the property. That should be the declaration.
No, if you read the para, they are follow, and it may be seek negative, but it's not actually negative. But we are seeking the declaration that we have not denied.
So you seek a declaration that they are not. So it is like this. If it is not B, it will become A.
No, how to my lord, I am not denying that rights. but I am affirming to that I am seeking the legal status of the property.
Oh, no, let's say there will be a declaration that he is not the LR of it.
Yes.
Automatically everything will change. You don't require a specific declaration for yourself.
Second player are already seeking also that the injection
That is not maintainable, that is a self-referred property. And more interestingly, my lords,
the self-purpose that is not property belongs to them. That is the contention of our.
First of all, according to you, if you are the owner of the property, that should be your primary relief. If you are the one, if there is a declaration that you are owner of the property, and then automatically that what negative relief you are seeking, that will happen.
Well, we have not seek any relief. At the threshold, it cannot be rejected. The plaint. Here in this case, my lord, that,
No, these kind of things are not.
no, that is only the.
We are not the binding precedents. What is the discussion? What is the ratio?
No, that-
What is this paper?
No, that is the.
We'll not look into these kind of orders. Please show some order where an issue is decided. Take that. Yes.
My lord, we continue paragraph 5.
Paragraph 5.
The petitioner defendant
You
has.
gave him a copy of it? Yes.
Paragraph 5, the petitioner defendant has filed a comprehensive suit of partition and possession, and the said suit the respondent plaintiff has taken up specifically that the suit of properties are approved properties by virtue of the registered deed and will execute in favor of the parents. Thereafter, respondent plaintiff has filed the present suit for mandatory indemnity claiming to be absolute owner of the suit property. The petitioner having the claim that he is absolute owner of the suit property and not claiming the co-owner of the subject property. The present suit is mandatory against the defendant is maintainable. Honorable Supreme Court in case of Santala Jain versus Authorized, the para 7 has said that in the present case it has not been shown to us as that the appellant had come to the court with the suit for mandatory injunction after any considerable delay which will disentitle him to discretion relief even if there was some delay. We think that in case of this kind of attempt should be made to avoid the multiplicity of the suit and the licensor should not be driven to file another round of suit with all attendant delay, trouble and expenses. The suit is in the effect. One for the possession, though the court in the form of suit for the mandatory injunction, as that would be given to the plaintiff in case of successive possession of the property to which he may be found to be entitled. Therefore, we are of the opinion that the appellant should not be denied relief merely because he had coached with the in the form of the
How is it relevant to your
mandatory.
case?
And that, my lord, that in such cases where it is court said that the full-fledged trial is required.
In what cases? How is the judgment applicable to you? It is altogether a different case.
No, that they are claiming that they are legal heirs of the deceased Balappa. We disputed that in initial stage. That matter is required to be
It's
tried.
not that. First of all, it should be what is that the relief that you are seeking, whether
No.
such a relief be granted. The court says they are not the legal heirs.
No, that burden lies on me to prove that they are legal heirs. I have to defend myself that I am the legal heirs of the Balappa. But when I prove that I am the only the legal heir, then
That's not the way the reliefs are sought.
there is a curable mistake, my lord, that can be cured in the initial stage. But at this stage, if it is rejected the plaint,
First of all, the point is whether such a suit is maintainable or not is the first point. If not, what you do for that is a secondary issue. First, do you agree that such a relief is maintainable?
yeah, under section 34, it is such a relief is maintainable.
Section 34 is such relief.
That is not barred under that we can claim the legal heirship. That's the status of legal heirship by.
You can claim, you are not claiming, that's a whole difficulty here. You can claim, but you are not claiming. You say that somebody is not.
The sum
If
of-
you say, I am the legal head, what is the negative that they are not? That should be the relief.
I would, that may be some lack of knowledge of that plaintiff has not been treated. That will provable mistake. We can make a necessary amendment in the plaint, and will at this stage if it is rejected, then it will become a decree. He can claim.
Who will tell you, when will you file the plaint?
Yes.
No, when you know you will, once you file the application, or you will amend the plaint.
No, that it was.
Yes.
Yes. How he suppressed the facts, my lords, how he has not approached the Malot court with a clean hand.
No, all those issues are not part
Yes,
of this
absolutely.
application.
In earlier
Please
too-
come to your application, let's see.
Yes, absolutely. Before that, my lords, my
Come.
application,
Hmm.
page 34,
30?
4.
Yes.
Yes, wherein for the reason assigned in the company affidavit.
No, you can come to the next page. the
Yes.
affidavit.
The relevant para, my lords, I take page 39 of my affidavit. Page 39. How he suppressed the facts in the present suit. In OS 142 of 15, he filed a suit for the partitions making me as the defendants. That suit was dismissed for non-prosecution.
What is that?
OS 42 of 2015, I think specifically stated in my affidavit, he filed suit for partition and separate possessions, admitting all the legal errors. However, he admitted on different issues. Partition and separate possessions.
Anyhow, for that, the court has to look at your written statement and all your
Written statement, in fact,
that cannot be decided at the threshold.
yes, written statement, in fact, it is not filed. However, the trial court says that written
No, let's forget that. No, if you seek an amendment of the plaint, what will happen?
if amendment of the plaint, my lord, that could be a different issue. The legal errors, my lord, is section 34.
It is something which can be cured, is it not? The relief that they have sought,
Yes.
they can amend the prayer, like, just like putting it from a negative to positive. But the relief amendment remains to be the same.
No, that entire change the nature from positive to negative, from one end to another end, my lord.
No, what they say is, they are the legal heads. Instead of saying that declare me as legal heads, they are saying that others are not the legal heads. No, that's for the court to decide whether
Yes,
they can,
ma'am,
that's such a, under order 6 rule
Assumption,
17.
presumption, my lord, that matters.
No, order 6 rule 17, when a petition is filed, court will
Yes.
decide whether such a relief can be granted or not granted, what is the stage of it, whether he is entitled for it. No, on that ground, can the plaint be rejected at the threshold?
Yes, section 34 is clearly barred. And secondly, my second point is this was, when my lords, he admitted the relationship and another 2 suits. This is the third suit. It is not maintainable.
No, that is for that.
Yes, for a moment.
No, from where we can look at it?
Admitted in the plaint.
Where did he say?
Yes, page 39. 3 suits, 1 SLP is pending.
No, before that, we will go to the order.
Yes.
On what considerations this order is
Yes.
passed. Page number?
Page number 58. How the trial court blindly passes an order, my lords, 58. Before proceeding, it is noted that defendant number 1 to 5 nowhere is stated in the written statement that the suit is undervalued, suit is barred by limitations. The plaintiff is claiming the negative relief. Hence,
No,
the
come to
suit,
para 24.
for a moment, before that,
Para?
para, my lord, 25,
20?
5,
Yes.
page 58.
Hmm.
Got balance? Yes. Before proceeding further, it is noted that the defendant number 1 to 5 is nowhere been stated in the written statement that the suit is undervalued, suit is barred by limitations, and the plaintiff is claiming a negative relief. Hence, the suit is not at all maintainable against the defendant. Further, they have not set up any defenses in the written statement. For the first time, the defendant set up those defenses. Hence, it is said that the defendants have suppressed the facts, materials accompanying affidavit I number 3. What prevented the defendant to plead in the written statements?
You have not filed the written statement so
I
far.
not at all filed. I had filed the order sheet. Kindly produce a lot of the memo dated 11/11/24. I had produced the entire order sheet. It is absolutely to some other matters.
He filed it.
Mechanic. Wait, let me finish, sir. Please. Mechanically, my lords, the court, my lords, without looking into the records, without going into the contents of my applications, scope of order 7 rule 11, my lord passes an order.
Mr. Counsel will set aside this order.
No,
We'll-
my lord,
We'll remand this matter to the trial court. Let the trial court consider everything efficient.
Yes.
My lord, yes, that, my lord, yes. Now, my lord, he made an application, my lord, before the revenue authorities on granting of, my lord, the injunction order. In all my record of rights, the stay order has been granted by the trial court.
In which case?
In the same now.
That you should have questioned it.
Yes.
You should have questioned
When
it.
it is sub judice before the honorable court.
That's what I'm saying. If such an order is passed, if you are aggrieved by that order of injunction granted by the court, you should have questioned it and your remedy is elsewhere. Now, as far as this application is concerned, court on some misconceptions, saying that you have not stated when you have not filed the written statement.
No.
That was all as if you have filed the written statement and not taken the contingents. An order is passed.
My lord,
For a moment.
the contention is that they have not filed, the court is not said that they have not filed the written statement. Court said that they have not cleared the contents of that.
Please understand, they have not filed the written statement.
They filed the written statement. It is there. They filed the written statement in the.
That is an IA for order 7 to 11.
What? This is the Prativadin Vandrinda Vakrishu Likita Vadapatra. Likita Vadapatra.
For a moment. How? For a moment. If
You can't have an order from, positive order from this court. That much, even however time you take and the court hears your argument, court is not going to pass that order. Let there be any judgment, but in these fact and circumstances, now we will set aside this order. We'll direct the court to consider your application and any other you want to file an appropriate application also. If anything has missed out, you can file an application fresh, and on that the court will consider.
Yes, my
And
lord.
we'll also fix a time frame for that.
Absolutely. If my lord permits me, only 2 minutes. If there is already a settled position, wait, my lords, and a suit has been filed by them, admitting the relationships. And my lord, that suit was been dismissed. Second petition has been filed, second suit has been filed, where they have not made me a party. In the said suit, they have compromised among themselves. And
All these facts, how will the court know?
we have specifically stated.
You have stated, can it be looked
And also
into?
produce the records.
Can it be looked into?
Yes.
By the court in a petition and order 7 to 11?
On the 7th rule, only one of the plaint contents is to be looked into. That is the basic.
And he has not stated about all you are saying so elaborately for the court to consider. For that, court has to look at your documents, your averments in the IA. They are not. That's not the way we look at it. That's not the scope of inquiry. So you have to wait for some time. Give court some time so that considering all your material, it will decide. As far as this application is concerned, the findings of the court are not correct. Let both of you, whatever you want to argue before the court.
Yes.
Let the court decide.
Yes.
But all those issues which you are talking about, that res judicata or is local, all that can't be considered in order 7 to 11.
Already, it is not the case that already records are there, court records are there.
But court records was to place before the court.
It is already placed.
Let that be looked into in order 7 to 11 petition.
But no. Yes, if that is the case, the court should not be looked into the written statement.
No, it will not look into.
It will
not look into.
Yes, even assuming for a moment I did not find any other.
That's why now what this court will say is,
Yes.
your application on order 711 should be strictly looking at the plaint. If anything can be done, the court shall do it. Not any other written statement, nothing will be looked
Yes.
into.
For a moment, if on prima facie looking into the plaint,
That's what prima facie only court will look into, which the court has not looked into. That's why we'll ask the court to do it. And in the meantime, what he wants to do, he will also do.
but pros and the cons, my lord, that my lord's predictions and my lord's appreciation that. So my lord's only on prima facie, my lord's the looking into the contents of the plaint is concerned. For that moment, my lord's the recently, my lords might note, my lord, the order passed by the Supreme Court has in many cases, only the contents of the plaint
Has to be looked into.
looked into. Here, relief, my lords, claim, my lords, it is absolutely against the law. My lord, where the reminding the matter, my lord, assuming for a moment, my lord, that the court has made an observation, I find written statement. Yes, absolutely. That whether even that circumstances also, my lord, that the suit itself is not maintained. Absolutely. For a moment,
No, it's an incurable defect.
34 may can you say?
Incurable defect.
Incurable, it is not at all a curable. They don't have a stand because the plaintiff was not born as on that day when my lords, my grandfather was died.
No, we are only on the point, the negative relief that we sought.
Yes.
I'm asking you, is it a kind of an incurable defect? Can't he amend the prayer?
If that is the case,
Contents would be the same.
yes.
Amendment prayer, it's only
If that is the case,
the prayer as it is formulated is not correct.
liberty may be reserved to them to file a fresh suit. I don't have any.
That I will not decide here.
No. Liberty may be reserved to file a fresh suit by curing all the defects. In the same suit, my lords, if
No, whole endeavor of you is that intermodal shall go. So that this suit goes,
Yes.
that intermodal that's granted against you will also go.
absolutely not.
That exercise this court will not do. Please come.
Or my lord, for a let us, my lords, frame a guideline for the honorable trial court, my lords, to the effect, my lords, looking into the earlier suits and also looking into, my lords, the admitting the relationship in the earlier suits, and also they filed applications before the honorable Supreme Court in my SLP. Their SLP, their application has not been allowed. I have been clearly stated in my affidavit.
What is the guideline you want to be given?
Only, my lord, for a moment, looking into, my lord, section 34, and also, my lord, the earlier suits which has been there, and also the earlier round of the litigation itself, and, my lord, the time bound to earliest as possible to dispose of the matter.
To dispose of the suit.
No, application.
This application, that I
Yes, I am not coming suit, my lord.
that's what.
But my contents, my lord, is
I'll record your
even assuming reminding the matter, my lords, again, it will come into the second round again. But what with the golden time of, my lords, the honorable judiciary, my lord, such a suit is maintainable. If such kind of suits are maintainable, it will go, my lords, entirely, my lords.
What you should understand is unnecessarily, no witness, you're talking about this golden period. Now again we permit him to file another suit. That golden period will go for another 15 years. So let the things be. Let the court set all the things at naught in the very same proceedings. Why should you again want them to file another suit? With the liberty, giving liberty to them. If the defects that are curable defects, let it be cured, and any of the issues that has to be dealt with as a primary issues, that you can file an appropriate application, court will decide. The I number 3, agreed with the orders passed in I number 3, in OS number 223 of 2029, dated 8th February 2024, the defendant is before this court. The respondent herein had, who is a plaintiff, had filed the suit seeking a prayer to declare that respondent number 1 to 4 are not the LRs of the late Palappa and Gaurava. Further, to declare that since respondent number 1 has illegally and fraudulently sold the property in the name of respondent number 5, and the same is now not binding on the Balappa's family, and the permanent injunction against respondent number 1 and an injunction restraining. I think even this advocate has not even taken 1 minute to draft and think. Before the trial court, he has not even taken 1 minute to even look at what has he drafted.
These are all suits, my lord, they are only prolonging the suits.
Actually, madam, they problem between taken the property, entire property and notify.
It's not about that, we are
No,
talking
here's
about,
the-
we are talking about
Yes,
the
yes.
draft,
Yes.
simple
Draft is
drafting, what is that?
Right, drafting is, we should not be.
And an injunction restraining the respondent 1 and 5 from not alienating the property. In that, an application is filed by the defendant under Order 7 to 11 to rejection of the plaint. In support of the same, an IA is filed stating that the suit of the plaintiff is barred by limitation and the plaintiff do not have a locus to file the suit. And further, the suit, the prayer as sought in the suit is also barred by Section 34 of the Specific Relief Act, and such a negative relief cannot be granted. The petitioner has also stated about the earlier suits that are filed and the earlier litigation that went up to the Supreme Court. And when the earlier suits were partitioned, where these petitioners are shown as the defendants, and later they came to be withdrawn, wherein they have admitted the relationship between the parties. Now, they cannot seek such a relief that they are not the legal heirs of Palappa. It is submitted, Palappa. The trial court, by order impugned, had dismissed the said application. While dismissing the application, the court observed that when they are saying so many things, what has prevented them to plead all these things in the written statement? And according to the as per the order, the plaintiff had not, the defendant had not pleaded all these things in the written statement. And for the first time, such a stand is taken in the IA filed before this court, filed before the trial court, at order 7 to 11. And further, the court comes to the conclusion that the suit is valued, a suit is properly valued and regarding the trial, regarding the prayer, the court says, observe that the detailed trial to be conducted by the court. Further observe that it's a contention of the defendant that the suit is undervalued and the suit is barred by limitation. And the plaintiff is claiming the negative relief and the suit is not maintainable against the defendants. Issues are also framed.
Issues framed, for a moment, issues were not. Issues at page number.
The court has already framed issues. Hence, the court has to conduct a detailed trial for adjudication of all the issues. And the defendants will also have an opportunity to urge their defense for non-suiting the plaintiff hearing. What are the issues? Page number
33. First issue is in no way related. Whether the plaintiff sued and sued scheduled property consists of the property of Balappa. It is against the main release. When plaintiff further proves that sued scheduled properties are allotted to the share of Balappa. Whether the plaintiff proves that the defendant number 1 to 4 are not the legal heirs of Balappa and Dharwad.
And as such, it has to be decided. Then why have you not asked for recasting of the issues?
Rejection of plaint is filed by us.
other applications for lots it will be status quo, it cannot be answered.
And accordingly, dismiss the application, filed for rejection of the plaint. Then counsel appearing for the petitioner submits that the court has failed to consider the application under order 7 to 11 in its proper perspective. The court had gone under a notion that in the written statement all these were not raised by the defendant when he has not filed the written statement itself. He submits that when it is a specific case that under section 34 of the specific relief act, such as to suit is barred, the court ought to have given a
limitation, and also the limitation.
And the limitation act, the court ought to have considered the same. It is submitted that all the contentions that are raised with the petitioner, defendant, were not considered by the court, and in a mechanical manner, application is dismissed. Next one. Then counsel is preparing for the respondent, submits that even if assuming that the prayer as sought by the petitioner is not maintainable, it is not an incurable, even assuming without accepting that that the prayer is a negative prayer, the same is not an incurable defect. He further submits that the court had rightly considered, and all these issues cannot be decided at the threshold, and it can only be done in the after a full-fledged trial. Next one. Having heard he submits that no interference is called for with a well-considered order passed by the court. Having heard the counsel's undersigned for the material on record. It is settled law that when an application is filed under order 7 to 11, the court can only look at the plaint developments and cannot take into consideration any other material. When it comes to the aspect of limitation is necessarily a question of fact and law. But however, in a given case, from the plaint and from the contents of the plaint, if the court can come to the conclusion that it is barred by limitation, still the court can decide the same. Here is the contention of the plaintiff that the relief as sought by the plaintiff, the suit is not maintainable, the set by section 34 of the specific relief act, and also about the limitation aspect. If the limitation aspect which he has raised is a mixed question of fact and law, and the same cannot be decided by the court, then necessarily an issue needs to be framed in that regard. And the manner in which the trial court had dealt with the application is not in a proper way, and court had failed to consider the contentions that are raised or raised by the defendant in an application filed under order 7 to 11. In that view of the matter, this court deems it appropriate to set aside the order passed by the court dated so and so and demand the matter to the trial court. The trial court shall consider the application and order 7 to filed by the order 7 to 11 filed by the defendant afresh and pass appropriate orders within a period of 2 months from the date of receipt of the copy of the order, accordingly disposed.
My lord, that matter is that he is submitted that he has not filed a written statement. But without written statement, the issues cannot be framed. And I record
the order sheet.
And that order sheet shows, my lord, that on 16/4/2021. Please, madam. That may be considered.
The court will consider, court will if that's submission that I have recorded. Just next.
Producing the order sheet along with the
That you have paid the bill.
Ah, First, my application is to be considered, because if the amendment application is filed, if they have considered that amendment application, my entire defense will be utilized. What the lordships are.
But nobody can, we cannot stop it. We cannot stop it.
But if with their amendment.
Then in that case, if really they come up with an application, it has to be considered.
So
As far as, no,
first, my application is to be considered, only that. Trial court will also now follow.
no. How can the court will say like that? How can this court say, even if he comes with an application, don't look at it first?
No, I am not
First you
saying.
reject this application.
I am
No,
not
first you reject the plaint, then consider his case.
First, this application is to be considered. Later on, let them consider.
How can it consider that application?
No.
For example,
Yes.
court comes to the conclusion that this plaint is not maintained, that it has to be rejected on so and so ground.
Yes.
For that particular ground, he seeks an amendment. Then what do you say? No, it has to be rejected first.
First, my application for rejection of plaint is to be considered. If it is dismissed, then these applications is maintainable.
No. Next.
Yes.
Not, no, what about this has not filed memo of acknowledgement for having paid the maintenance?
Till today, they have not paid.
Total arrears are paid.
No, my lord. Entire order sheet may kindly be for you. Records are here before this honorable court.
Have you given him a copy?
I am having the certified copy itself. First, I request this honorable court to kindly go through the orders by this.
Let him what he wants to tell. Let's hear. Yes.
Yes, total arrears is 2,56,000.
2 lakh?
56,000.
Uh,
I have paid.
uh.
I have paid the total amount.
Where do you get it? Where do you get it from the order sheet?
Page number 9.
Page number 9. Two lakh paid today.
Yes. Only that amount.
He says 2,56,000 is the arrears.
It is his say. It is his say. My lord, let the petition which has been filed by the petitioners may kindly be said. It is 7 lakh in all. 19,000.
Now, what is the order of this court? Let us
Yes.
see.
That's why I am requesting this honorable court to go through the order dated 31/8.
30?
31/8. How false submissions have been made before this honorable court to obtain
No,
the
let's
interim order.
not, please don't say all that. It's whatever it's instructions or you might be submitting.
And even notice has been not ordered to the respondents in this case.
And counsel, the petitioner submitted the petition is up to date so far as
Yes.
payment of maintenance, seeks an interim order of stay. Until next date of there shall be interim order of stay subject to the clearing interior research when you continue to pay. You, not this, you what all you have paid from the date of petition till now, file a calculation memo before this court and serve a copy of it in advance to him. And please tell, and once if the court finds that you have not paid the arrears, and as per the order before this court, you have submitted that, then appropriate action will be initiated against your client. Please tell him that.
The order has been passed by this honorable court on 31/10.
Huh?
31/8, this honorable court has passed the order of stay. But whereas the amount has been paid after 2 months before the trial court.
This court had observed by order dated
31/8.
31/8/2024 that the petitioner submits that he has cleared the arrears up to date. As the court observes that until the next date of hearing, there shall be interim order of stay subject to petitioner clearing entire arrears of maintenance, if any, and continue to pay maintenance of ₹6,000 per month in case of respondent number 1. Learned counsel appearing for the petitioner. There are 2 petitioners here.
No, ma'am.
Two
Three.
respond- two
Petitioner is
respond.
allowed.
The learned counsel appearing for the petitioner submits that the arrears are 2,56,000 and he has already paid 2 lakhs. 2 lakhs or the entire 2,50,000?
Entire.
entire amount. Land counsel appearing for the respondent submits that the statement that is placed before this court is not a correct statement, and the arrears are running into lakhs.
Now it is 6,40,000.
6 lakhs?
40,000 till today.
6 lakhs 40,000 till today. Learned counsel for the respondent shall file a calculation memo, and the same should be served on the petitioner. Thereafter, the petitioner should also file a calculation memo before this court by serving the same on the counsel for the respondent. This is matter on 26.
The counsel for the petitioner will be directed to serve the copy of the petition because no notice has been ordered.
Petitioner shall serve the copy of the petition, a copy of the petition on the counsel for the respondent.
Date will be fixed.
Yes, 25th, what did I say? 26. 26.
Please.
Yes.
Number 21, RHI, Survey Secretary.
Second RPFC is for the enhancement by the husband. Wherein I have already deposited an amount of 4,85,000. On the last occasion, I have made a submission before Honorable Court. Since they want to withdraw the entire amount, in my first submission, some amount may kindly be kept in FD in favor of the minor children that can be utilized for their education. Lordship, the order was passed in the month of March for granting 6 weeks time allowed. We deposited last month itself the due, and there is an order in this petition, my lord. We shall go on paying 9,000. 3 children and wife are there. 8,000 to the wife, 2,000 to the children. 8th standard, 6th and 4th standard students are there. So, my lord, this doesn't hold any right, madam. You would have deposited then except only now. He has not deposited. Permit me to withdraw the entire amount.
I number 1 of what is that for withdrawal? You filed any?
No, my lord, I had not
Learned
filed.
counsel for the respondent submits attached for the order passed by the court. The father, the petitioner had deposited the amount, and they were permitted to withdraw. Learned counsel appearing for the husband submits that they may be permitted to withdraw some of the amount, and some of the amount may be kept in the fixed deposit, which will be useful for the children. Considering the fact that there are 3 children, and all the arrears are being paid at once, and this court finds no reason to pass such an order. Accordingly, the respondent is permitted to withdraw the amount that is deposited. This matter on 17th December.
Lord,
Yes,
it is before this honorable court. Before this honorable, this.
Yes.
Number 20,
Short account.
This matter on 3rd of December at the request of unconscious petitioner. Yes, 20. Yes.
number 21,
This was the petitioner letter. The
There is a
present
translated copy.
that have filed.
What is the CRP?
CRP is filed against Millard, the order passed by the trial court on I number 3 Millard, where the defendant had filed an application under order 7 rule 11 is 1
Rejection of the
D of
plaint.
the rejection of the plaint.
So what did you write?
That the suit was Millard filed for declaration and permanent injunction.
I'm looking at your affidavit in support of that.
Please.
So whatever that you have stated about that you are the owner and all those things have to be decided by the court. Next, the plaintiffs have filed the present suit seeking the relief of declaration for permanent injunction, but the suit is not properly valued and sufficient court fee is not paid. This is one aspect. And how is it barred by limitation?
Millard, the first contention, Millard, is that the suit has no cause of action.
The very reading of the plaint, my lord, does not disclose.
Let's look at it. Look at the plaint. What is the cause of
Paragraph
action? That's
7, my
stated.
lord.
Cause of action for the suit arose to the plaintiff in the month of September when the plaintiff obtained property extract mutation entries pertaining to the suit land and name of the defendant number 1 being appeared in the respect of the property, and subsequently in the second week of November 2020 when the plaintiff requested the defendants to rectify the entries in respect of the property, and the same is denied by the defendant.
Yes, that is the cause of action, my lord, that they contend that it is arising in the year 2020 November. But, my lord, the basis for filing the suit, my lord, is the father of the plaintiffs, my lord, said to have been adopted by one Nilova. The plaint does not disclose, my lord, when that Kenton Goda, who is the father of the plaintiff, was adopted to that Nilova account. It is a simple statement that their father was adopted to Nilova.
No, this kind of roving inquiry can the court do. That they will do it, eventually they'll prove all that.
When the basis for their claim, my lord, to file a suit is
And let's
that
see the other paragraph, let's see.
the very contention of
From what time the document is standing in your name, or the entries are in your name?
the petitioner, my lord, has succeeded to the property through the mutation, my lord, transferred by one Lakshmi Bai
Which year?
in the year 2011 itself. Before that, my lord, in 1984 itself, in 1988 itself, the entries were transferred in the name of one Nilava, to whom, my lord, they claim their
Please
father
come,
was
and
adopted.
also the petitioner submits that without there being any cause of action. And to get out the limitation without even not without stating the facts, and a plaint is filed and an application filed by them, order 7 to 11 is rejected by the court without considering the contentions in this proper perspective. Accordingly, considering the submission of the land counsel, there should be stay of all further proceedings in OS number 104 of 2020 till the next date of hearing, and the petition is permitted to take out hand summons on the counsel appearing before the trial court, and shall file a memo to the effect by 11th December and list this matter on 12th December. The 12th December. If the memo is not filed, the interim order granted by this court stands vacated without further reference to the court. Yes.
Notice also.
Notice,
in
ministry is directed to issue notice. In addition to that. Yes. Earlier matter, the withdrawal matter, interim order all granted is extended. Yes, 24.
Petition number husband petition. There is included order at page number 26.
How much is granted?
15,400 members.
Huh?
15,400 members. My salary is 26,000 members.
20?
26,000 and ex parte order is 20,000 members.
How much will deposit?
50% I will deposit members.
That council submits that the salary of the petitioner is 26,000, and the court has granted maintenance of an amount of 15,400. Considering the submissions, they should stay of all further proceeding pursuant to so and so, on the condition that the petitioner should deposit an amount of rupees 8,000. By continuing to deposit an amount of rupees 8,000 by 5th of every succeeding month, and the arrears at 5,000 shall be paid within a period of 8 weeks from the date of receipt of the copy of the order. Either of it, if they are not compliant, stay granted by this court stands vacated automatically. Registry is directed to issue notice to the respondent. This is matter on 11th of December. By that time, the petitioner should file a memo of paying the in support of the payment that is made. Yes, next.
Please.
My second of objections are ready, but to take a verifying to signature on the verifying affidavit, I kindly be password.
Password not possible. List this matter on 20th.
Number 26.
Huh? Ultimately, court will transfer. Give him an opportunity. Then counsel for the respondent wants to file his objections. Yes. On 20th. Yes, next. 20th 25th. Yes.
Please.
Yes.
My lord, seeking transfer of the petition, suit filed by the husband, my lord, by the respondent number 1 to family court Dharwad, my lord.
From where?
From Kustigi, my lord. Koppal district.
What's the distance?
My lord, it is about 180 kilometers from.
Then
where-
council submits the husband has instituted OS number,
It's 11.
MC number 11 of 2024 on the file of the senior civil judge and JMSC Koppal. And the wife is a resident of Dharwad. And the distance between both the places is 80 kilometers.
180 kilometers.
180 kilometers. Considering the submission, there shall be stay of all further proceedings and so till the next date of hearing. Then counsel for the petitioner is permitted to take out hand summons on the counsel appearing for the respondent before the trial court and shall file a memo to the defect by 10th. If the memo is not filed, the stay granted by this court stands vacated without further reference to the court. Yes, next.
Please.
Petition. Wife and child petition for enhancement of interim maintenance.
Huh?
Wife and child petition for interim maintenance, enhancement of interim maintenance.
Notice. This is the tuition notice to the respondent. You will take out person or notice or has hand summons on the.
No, notice actually.
Yes, next.
Number 28, will that provide?
Today, we have responded to Wakalat.
Learn counts for the respondent submits he has received wakalat today. List this matter on.
On 28th, it is posted for judgment, Lords. And because I talked to us that mediation.
20th is posted for judgment. Then we'll have it on 19th.
Maybe refer to mediation, unless there were talks that once and final settlement.
Please.
Shall it can be deferred?
Please, Nancy.
Both the parties submit that there is a likelihood of settlement. 14th is possible. Today, Thursday is 14th, no? 21st. But the judgment is on 20th, 19th. Then we'll say 19th. The party shall appear before the, they submitted that there is a likelihood of settlement. Both the parties shall appear before the mediation center on 19th. On 19th. Yes. Huh?
Marking.
Yes.
Please.
Number 29, rejection.
Husband petition matters, challenging the interim order granted to respond number 2 daughter matters.
Keep that mic for open.
Husband petition matters, challenging the interim order granted to respondent number 2 daughter. The trial court has granted 8,000 rupees along with the educational expenses of the daughter.
What's your salary?
45,000, my lords. However,
What are the educational expenses?
they have exorbitantly held it as, they have given it as 1,50,000 rupees.
So 1,50,000 per annum.
They are asking it from the filing of the petition, my lords, per annum. It is my contention, my lords, it has also come on record that respondent wife is a working and drawing, she is a full-time lecturer having a salary of 45,000, my lords.
So you're questioning this maintenance part or the educational expenses part, or both?
I'm ready to pay 50% of the educational expenses and.
Has it come on record that she is earning?
Please, my lords, I have taken it into consideration.
You must have stated whether there is a finding that she is working.
No, my lords, it has not taken into consideration regarding. I'll produce the documents relating to the same, my lords.
Because all the educational expenses, we can't say that what will happen to the kid if mother is not in a position.
I'm ready to pay the educational expenses, my lords.
When counsel petition submits that the court, apart from the educational expenses, has directed the husband to pay 8,000 as maintenance, and they're seeking. It is the case that the educational expenses are 1.5 lakh per annum, and they're seeking from the date of petition, considering the same. As far as the educational expenses are concerned, this court is not interfering with the same. And as far as the maintenance that is awarded, the same is reduced to 4,000. And in the meantime, there shall be stay of all further proceedings. as far as the monthly maintenance on the condition that the petition shall deposit 4,000 by 5th of every succeeding month and the arrears at 4,000 within 8 weeks. Same, either of it does not comply with the appeal, the petition stand dismissed. And next, the petition is permitted to take out answers on the counsel advising for the respondent before the trial court and shall file a memo to that effect by 9th of December. If the same is not filed, on that ground also, the petition shall stand dismissed without further appeal to the court. Yes.
Obliged.
Order business number 30. Game of small. What's your
Yes.
Religious petition number 17. Husband is a retired. Husband is a retired man. Wherein 10,000 is allowed. And wherein it is
Even on that day he is retired.
yes.
Uh,
Wherein this is third round of maintenance.
what is her age?
However, she is with two sons who are well settled at Bangalore. And one is at
How much pension you are receiving?
30,000.
Hmm.
30,500.
Why you can't give 10,000 to the wife?
Why? Because the petition was filed in the year 2015. In the 2019, it is transferred to family court. Wherein earlier the claim of rupees 5,000 per month was. After transfer to family court, in the year 2021, the petition got amended, wherein 20,000 was. When till the transfer to family court in the 2019 and 2021, it got amended. Where to the claim of 5,000 till the 2021, wherein after it is taking into account from the date of petition not filed in 2015, 10,000. Earlier occasion it was only a claim for 5,000. And as far as earlier proceedings are concerned, it was regularly paying maintenance. After this is the enhancement, seeking enhancement. Subsequently, it got amended to 20,000, wherein family court awarded the.
When is the petition for enhancement is filed from 2000 in the year 2015?
2015.
Order is passed when?
Order is passed in the year 2022.
20? Yes, what do you say? He retired when?
May I pass on his pension slip?
He retired when?
2013.
2013.
May I pass on his pension slip?
And you're staying with your children, sons, is it not?
No.
Huh?
She claims that she is not living independently.
Why you are not staying with the sons?
But he has two sons. She has two sons. They are also looking after her. Madam. Now the question is, he is a class 1 gazetted officer. This is a 40 acres of land. Madam. And they are residing separately from last 24 hours, 24 years. In the year 2006, he was paying 1,000. In the year 2015, I sought for an amendment. So far, he was paying for only 1,000 rupees per month.
No, if the arrears have to be calculated.
Please.
From 2015 till now, that is 9 years.
Please.
9 years at, for example, this 10,000 has to be.
Yes.
How much is the amount? How will he pay?
No, he is more than sufficient of income, because
Where?
his 50,000 is pension. Your Lordship will find it 9th column from bottom. 53,300 is pension.
No, total pension paid is 46,450.
That is after deduction. So, sir, 10,000 is, in fact, being a class 1 gazetted officer's wife, she was working as a dishwasher. She was doing that. Now she is more than 63. She is not able to walk and do significant. So, this is the reason.
Yes.
This considering the tendency of this till from 2021 till earlier from 2015 to 21, 5,000 to be taken into consideration. After 2021, taking into account present pension.
We'll do that.
No, Rajneesh versus Neha, Lordship is.
So that is, law is there.
Please, ma'am, because.
Law will not be applied just like that. It all depends upon the facts and circumstances of the case.
Please, ma'am.
No, at a time, if he has to pay, he is also a retired employee. Now you will get that from the date of that, from 22 From 22, let it be 5,000, 10,000.
If we look at, may I take your lordship's judgments, sorry, at page 11, my lord, wherein the court has pointed out the conduct of the 40, my lord. During up to 2006, my lord, he was paying 400. And later that, my lord, it was enhanced for 1,000. Till 2015, my lord, she was residing in only 1,000. Though he has more than sufficient, he has, in fact, my lord, he has received for 40 lakhs as a retirement benefits. My lord.
Agreed with the orders passed and given miscellaneous number 59 of 2019 dated 29th August 2022. The husband is before this court. The wife had filed a petition under section 127 CRPC seeking enhancement of maintenance to 20,000. It is a case of the wife that husband is a retired employee. It is a case that the parties are residing separately in the last 24 years. In the year 2006, she filed an application to enhance the maintenance, and the amount was extended to rupees 1,000 each to her and to the children. According to her, she is staying in a rented house and suffering with diseases, and she requests 20,000. She is doing maid work and earning money for her livelihood. According to the husband, he is drawing a pension of an amount of rupees 30,500, and he has looked after the marriage expenses of the 3 children.
That is all is in dispute, my lord. That is all is in dispute. Because, my lord, they were residing separately.
I am only considering the submission. Submission. It is this case that both the children are in good positions and earning good salary. And as she is staying with them, she does not require any maintenance from the husband. The trial court by order impugned had granted an amount of rupees 10,000. While granting the amount, the court has observed that just because the children are doing good, that cannot be a reason for the court to absolve the liability of the husband. The court observed that he has retired as a registered manager from BUO office, and he would be getting other extra benefits like gratuity, EGIT, and provident fund, etc. The pension payment order shows that rupees 13,700 pension is fixed on the date of retirement, which is of the year 2013. He also taken commutation of rupees 80,638 and DCRG of rupees 6,78,150. And also that is drawing the pension of rupees 30,500 is admitted. The court observed that when he is enjoying all this, the amount that was ordered long back of 1,000 is not correct, and enhanced it to 10,000. Agreed thereby the husband is before this court. Then counsel has reiterated the contention that arose before the trial court and submits that he is a retired employee, and the court went wrong in granting 10,000 as maintenance to the wife. The wife is sufficiently maintained by the children, and all these aspects were not considered by the court. Next paragraph. Let counsel appearing for the respondent by submits that when the husband has received retirement benefits of 40 lakhs, and is also getting the pension of 50,000 with 4,000 deduction, 4,000 and odd deductions. He submits that the wife is working as a maid in working.
She used to work in back in the year 2000 up to 2013.
He was working as a maid to 2013. Now, because of her growing age and ailments, she's not in a position to work. And her husband, who is having a comfortable lifestyle, cannot has a responsibility to take care of his wife. Having no the counsels on either side, there is a material non-account. The undisputed facts in this case are the husband is a retired employee and he got the retirement benefits as well as he's getting the pension around 46,000. The 46,000, according to him, the children are educated and are drawing a handsome salary, and they will take care of her. When he admits the facts that is receiving pension of 46,000, and has no material to show that, as far as the wife is concerned, she has no means. In that case, on the ground that the children are studying, the husband cannot say that he will not do his obligation. That amount of 10,000 that is granted by the court, considering the financial condition of the husband and the considered opinion of the court, is a well-considered order and it requires no interference from this court, according to the petition.
From the date of the petition to the
No. Yes. Yes.
Appearing on behalf of the petitioner, my lord.
Yes.
My lord, in my last submissions,
Request is adjourned.
Honor-
What is this matter?
this is about the maintenance, my lord.
Granted to the, you're for the husband.
I'm from the husband. Okay.
How much is granted?
20,000, my lord. I'm an agriculturist, and it's an admitted fact from the wife side as well that the house runs on my ED. And I'm a 50-year-old with cardiac disease, so I cannot do hard labor anymore.
What is your age?
52, my lord. And it's an admitted fact that she is.
You sought for time.
My lord, it's just and proper manner. Whatever the others has been passed by the trial court, it is just and proper. It is evident that I'm working in a school and earning around 12,000, and I'm paying monthly rent of 6,500. And my daughter who is with me have to look after her school and her.
But 20,000, where is the material for the court to come to that conclusion that he can afford to pay 20,000? Please come to the reason part.
My lord, kindly please look into the deposition of the respondent husband.
Come to paragraph number 10. Please.
It is also the specific allegation of the petitioner that though her husband being financially very well, having agricultural land at Dharwad, urban Papa village, and as well as having an RCC building in Dharwad, having other source of income, has failed to neglect her and her minor daughter. It is to be noted that, and it should not be lost sight of the fact that the petitioner has clearly and squarely admitted that she being working in a private school, but her income of rupees 12,000 per month is not at all sufficient for their daily living, wherein under she is residing at a rental accommodation and paying rupees 6,500 per month, and remaining salary is not at all sufficient both for her daily subsistence as well as her daughter's educational expenses, which admitted that petitioner number 2 is a school-going child. And it is also to be noted that petitioner has produced the school fees receipt at Exhibit C7, which shows that the minor petitioner number 2 is studying in the 10th standard at Dharwad Education Trust, GG Fitness English Medium High School, and having paid rupees 8,700 of May 2022 and rupees 2,500 each as
You
a
filed your
monthly.
statement of assets and liabilities.
I'm sorry.
You have filed the statement of assets and
Yes.
liabilities.
Yes, ma'am.
Where is that? Record is there. Record is there. You have with you.
No, my lord. This has come as an announcement.
My lord, in his deposition, he has admitted, my lord, at page number 12, my lord,
Yes.
shall I read it? No?
What is that? Sum and substance of it.
He has admitted that he has a four-wheeled vehicle in his name, my lord. He's telling that the loan was given by his brothers. And apart from that, he has 3 acres, 5 gunta agricultural land in his name as Nikki.
3 acres, 5 hectares of agricultural land, 20,000 per month. And how much it is for a year? 2,40,000 will be the income from the 3 acres.
No, my lord. Apart from that, he has a house, my lord. And he has another
Does it,
4 acre.
has he given it for rent? The
That
house?
that
It's not that. So anyhow, that will not, there will not be any income from that.
My lord, totally he has 7 acres, 6 guntas land in his
So
name.
where is it elicited that how much, what is the income from that? Because 20,000 is a big figure for an agriculturist.
It will become a problem for me as well, my lord, because I am earning only 12,000. I have to look after my child who is studying in an English medium school.
My lords, I have 2 other children with me along with my age-old parents. Together we have 3 children. One of the child is staying with her. The rest 2 refuse to accompany her and they are being taken care by me.
So 2 children are with you, 1 is with her.
One.
They have forcibly kept those both the children.
If you, in MC number 31/21, my lords.
We'll make it 10,000.
Please, my lord.
We'll make it 10,000.
My lord, please, ma'am. Because I have to look after both my child and myself, my lord.
Then who will look after your 2 other children?
My lord, apart from that, his father is also having property, my lord.
That's not a ground for the court to grant maintenance. The agreed with orders passed in criminal miscellaneous number 264 of 2022 dated 11 December 2023. The husband is before this court. Wife had filed a petition seeking maintenance of an amount of rupees 25,000 per month to herself and 15,000 to the minor daughter. It is a case that the husband has failed to take care of her, and also MC number 31 of 2021 is pending before the court.
My lord, MC number 31/2021 has been decreed.
Granting divorce.
No, not the divorce,
was
not the
allowed.
dissolution. The restitution was allowed, my lord.
Filed by you.
Filed by me, and the wife has failed to accompany.
Then you filed a divorce.
She has failed to accompany me, my lord.
Immediately they have filed the, my lord, they don't have the intention to take me, my lord. Immediately after, when it was allowed, immediately they have filed the divorce petition, my lord.
My
That's
lord,
pending.
It is pending, my lords. And
And that is MC number
Just a minute. It is
31
MC
of 2021.
Just a minute.
It is submitted that the husband has filed a petition for restitution of conjugal rights, and immediately, without even giving an opportunity to her to join, MC and another MC is filed seeking divorce, and it is a case that she requires 25,000 to maintain herself and her daughter, 25,000 for herself and 15,000 for her daughter. The respondent has filed his objections. It is his case that the wife has failed to join the husband. As such, he is constrained to file the petition seeking divorce. It is his case that out of 3 children, 2 children are residing with him, and he has to take care of the 2 children and the aged parents, and he cannot pay the maintenance as sought by the wife, and wife is earning. The trial court having.
Sorry to interrupt in between, manner. He says that he has kept 2 children, manner. Kindly please see his deposition, manner, at page number 11.
Yes.
He has his second daughter. He is sending her to do work in other farms, manner. It shows that he is not even looking after those two children as well, correct, my lord?
They are staying with him.
Yes, my lord, they are staying with.
Who
no
said
father.
that he is sending them to the
He
farm?
only himself he has admitted it, my lord.
No, that
That he is sending his second daughter to work in other farms. When he has his own agricultural land of 7 acre, 5 guntas, my lord.
but children are not studying.
Children are studying, my lords. Both of them are studying.
Then
And
what is the
it was
vacation?
during vacations that we have to support the family together and pay the maintenance, my lords.
It's
20,000 is being,
shows, my
That,
lord.
right. What is that?
and the MC number 31 by 2021 was the restitution petition which was allowed.
Children had huge balance and he cannot pay the maintenance as sought by the wife and wife is earning.
Fine. Let counsel appearing for the respondent wife of the son, as per her own admission, as per his own admission, he is having a four-wheeler and he is having other landed properties. It is submitted that he
And
is
a
also,
house in his name, my lord. A building in his name.
and also,
My lords, I'm extremely sorry. The house property and other landed properties are joint family.
please understand what the court have already said, what is the court doing? Let us say
Much of it.
is also having the house properties. It is submitted that in his evidence he has said that he is sending one of the daughter to the farm to work, which shows that he is not taking care of the children. Then counsel submits that she's earning 12,000, that is not sufficient for her to take care of to take care of herself and the other daughter. It is submitted that the court, considering the difficulties faced with the wife, had rightly granted an amount of rupees 20,000 as maintenance, and no grounds are made of seeking interference with the well-considered order passed by the trial court. Next part. Having heard the counsel sorting the said peruse the material on record, the undisputed facts are the MC that's filed by the husband for restitution is decreed, and thereafter husband had filed the MC. According to the wife, the husband, without even giving an opportunity for her to join, has filed an MC for divorce, and he has no intention to take her. According to the wife, she's earning an amount of rupees 12,000 per month, and the same is not sufficient to take care of take care of both the maintenance of herself and the daughter. The husband, the two children are staying with the husband. The reasons stated by both of them are not genuine for consideration for this court in this application. According to the wife, the husband has stated that that one of the girl is working in a farm. According to the husband, to pay the maintenance to the wife, all of them have to work. Next. According to it is also an admitted fact that the husband is an agriculturist, and he is having land measuring an extent of
7 acres.
7 acres.
5 guntas.
Please, my lord. It is only 3 acres, 5
Sorry, my
acres.
lord. Please, kindly look into the paper.
The rest of them are joint family properties for which she has filed a petition.
My lord, please.
The properties is having landed properties, and some of the process 3 acres and odd is on his name, and the remaining properties are
Sorry,
the joint
madam.
family.
Please, madam. Please let me make this. Shall I make this, madam?
Yes.
ತಮ್ಮ ಹೆಸರಿನಲ್ಲಿ 1 4 ಚಕ್ರದ ವಾಹನ ಇದೆ ಎಂದರೆ ಇದೆ ಎಂದು ನುಡಿದ ನನ್ನ ಅಣ್ಣನವರು ಲೋನ್ ಮಾಡಿ ಕಟ್ಟಿದ್ದಾರೆ ಎನ್ನುತ್ತಾರೆ. It is as per Niti 9, madam. He says that he has a 4-wheel vehicle.
That is, I have already dictated. It's over. Then.
Apart from that, madam, he has and read out everything, madam. It's just 10 lines.
Ultimately, what is the land he is having? That you please tell the court. Anyhow, whatever you read is not going to make any difference in the order.
In his name, 7 acres, 6 guntas.
Yes.
And 1 building in his name, madam.
Yes.
And apart from that, in his father's name, madam, as per ನಮ್ಮ ತಂದೆಯವರು 3 ಜನ ಮಕ್ಕಳು ಸರ್ವೆ ನಂಬರ್ 27/1, 27/3, A3, B3, K ತಮ್ಮ ತಂದೆ ಹೆಸರಿನಲ್ಲಿ ಎಂದರೆ ಸರಿ. These all are in his father's name.
How much?
That I don't know, my lord. Is that
Yes,
the
it's
survey
7
number?
acres and odd land is in the name of the petitioner and
And
some more
apart from
land.
that, 4 to 5 houses.
Some more
property
land is in the
name
name of his father. The fact remains is that he is an agriculturist. And the court had granted an amount of rupees 20,000 without even considering the fact that the two children are residing with the husband. The husband had to take care of the two children as well as the parents. These aspects, this discussion is absent from the order passed by the trial court. Considering the fact that she is already earning an amount of rupees 12,000, this court deems it appropriate to modify the order, reducing the maintenance from rupees 20,000 to 10,000. Accordingly, this court is passing the following order. The order of the trial court is modified and the amount maintenance is reduced from 20,000 to 10,000. Yes, next. Yes. Where is the respondent? Yes.
Sorry, entry model, refusal to stay the eviction order in HRR. Last time I brought it to law, I'm
I think not today, this matter, because it requires, I'll have to pass an order, it takes time. I remember that you say that there is no tenant and landlord relationship, that the suit is not maintained.
Yes, I'm agreement holder now.
Yes.
Not married.
When do you want? This is matter on 26th of November. Interim order earlier granted is extended till then. Yes, next.
27.
20? 27. Yes.
Vice petition, my lord, seeking enactment of interim maintenance.
We can see it later. This is matter on 27th November. Yes, next.
Yes, what happened? One development has taken place. Now the husband is having a benefit of a decree of divorce. That is, of course, an ex parte. After 1 year, my lords, a notice came from the appellate court, that is, the High Court, my lords. But by then, my lords, she is already married. So what I am suggesting is, if you have to come with a proposal, we shall set it once for all.
By the date the matter comes up next time, we'll have instructions on that. Yes.
Great.
Yes, next.
Submission of the last date of hearing, the directly to raise an affidavit of the petitioner stating that he has not violated anything. Now we are to be admitted in hospital and he is getting treatment for local asthma. So may I request for weeks and
This is matter on 22nd at the request of non-counsel for the petitioner. By the time no further adjournment will be granted, by the time the as directed by this court, an affidavit shall be filed. This interim order earlier granted is extended till then. Yes, next. There's no representation for dismissal on 10th of December. Yes, next. We at the request of non-counsel, the petition list is matter on 28th November. Yes, next.
An order passed by educational appellate tribunal. In fact, we had file a earlier writ petition. This honorable court will directed me, of there was confusion whether an order passed by the tribunal as such, not question whether it's work tribunal or educational appellate tribunal.
Now the law is here.
Yes. No, Lord, so far as the orders passed by the work tribunal is concerned, CR, as against the orders passed by education appellate tribunal, it is against writ petition. But I may have to reconvert it to writ petition.
This is against what?
Educational appellate tribunal.
2020, when is the judgment?
This My lord's full bench judgment, my lord, is in 2019.
But why, what are you doing from 2020?
My lord, the conversion took place, my lord, in 2020. My lord, subsequent judgment is 2022.
22. That's what I'm saying.
Yeah,
We're in
I'm sorry,
24.
I'm sorry.
We're in 24.
Yes.
That comes for the petitioner submits that in the light of the law laid down by the full bench, against the order passed with the education tribunal, only a writ petition lies, and they did file appropriate application seeking conversion. This is matter when?
26 or 27.
On 27.
Wait.
Yes, please.
This number? The number one?
Any date. He said that in total number 2.
This is matter on 23rd working day, 23rd. Yes, next.
Please.
I request for 26, Your Lord.
25th. You should have informed him. We have been waiting.
Please, for this only matter.
Post on because today is like positive of time. Otherwise, I would have taken.
I understand.
Yes. Yes, two.
Okay.
The number two? Are they there?
Yes. So
What is agreed to pay another lakh along with the lease.
then file a memo, both of you.
Yes.
Tuesday
Yes.
or Wednesday.
But
Because
Tuesday.
you have to, Tuesday works, it is submitted that the wife, the husband has agreed to pay an amount of rupees 1 lakh in addition to 1,50,000, which is, in addition to 1,50,000 for the amount which is lying with the owner as a deposit, in the house which she is staying. It is submitted that she will vacate the premises and she can have that one. The land council, the petitioner submits that she'll vacate the premises. Land council responded, submits that she can have that 1.5 lakh in addition to that another 1 lakh. Is ready to pay 2.5 lakhs as a full and final settlement towards the maintenance of the wife. And in that regard, they'll file a joint memo before this court. Is this matter on Tuesday?
Tuesday.
The number three? We are saying the number?
Needful has been done, number respond number 7, the copy is filed.
Land council, the petitioner submits that the needful is done. Yes, let's this matter is under which caption now? Orders, leave this matter for admission if all the office objections are clear. Yes.
The number four? Are they?
And I'm glad on the case of N.D. Tiwari. Very well, honorable apex court has held. I am referring to 486 point on the last page.
Actually, on this, there are several line of judgments.
There
Have
are
you checked that what is the fate of this order before the apex court?
no, this has attained finality, Manoj, and
That's what I'm asking. It is a Delhi High Court judgment.
no, yes, and this has attained finality, and it is proved that the person who has approached the honorable apex court is the son of N.D. Tiwari, the then minister, central minister, Manoj. It is proved, Manoj.
And that order is upheld.
Yes, yes.
And is it an 125 CRPC proceeding?
So far as 125 CR,
That's
there
it,
is
that's
no
it.
direct that is judgment on the point.
No, the point is the manner of inquiry under 125 is summary in nature. I think there is some judgment of some high court recently
Yes, ma'am.
where they have said that even for 125 also if paternity is questioned, it has to be done. Which court is that? Allahabad or Delhi?
Allahabad, I did not know, but the law which is laid down by the honorable apex court is where it is categorically held that when a person is seriously disputing about the paternity of a
For
child,
that you have to, no, if you file an independent suit for
but
that.
MC petition is pending for consideration.
Or
Wherein
in
a-
the MC,
yes,
MC that can
wherein
be
he has
decided.
made an allegation.
No, in MC it can be decided,
Yes.
but not in 125
But
CRPC.
until then, if the court passes an order against me, for maintenance.
No, you can always seek such an application that this is what it is. So like till this matter is decided by and I'm already filed an application questioning my
But I have
paternity.
filed a petition on the ground of that is allegation of adultery also. And I arrayed the adulterer as a party in the same proceedings also, madam.
Correct. In that, if you have
Yes.
already filed an application of 120 and on this, then you can say that till as long as it is decided that she cannot. But we, on that
No,
ground,
may,
we
may,
can't
may,
direct.
may I make a submission before this honorable? Pending consideration of MC petition, there should not be any order by the
But
JMC court with regard to maintenance, madam.
where is the application filed by you in the MC petition that you can show to the court? Then we will say.
May I seek each recommendation, I file that.
List is marked around 26th.
Yes. In the meantime, further proceedings, since madam, the matter has now reached for final argument.
Problem
If the court passes an order, they
No, like,
will
for
give an adverse influence against
granting an interim order, anyhow, the day it comes that in the MC it is decided that she is not your so-and-so is
by
not
that time, if the JMC court passes an order, that the children are intact for maintenance, then it will give an adverse influence against me, madam. For the same reason.
No inference because it is not decided by the court. Because court has not decided about the paternity, which is pending consultation before the MC court.
At least that observation may kindly be passed by this honorable court, madam.
That
Observation may kindly be passed, madam.
without
Until
notice.
then, madam.
Without notice to the respondent. Without notice to the respondent.
No, emergency notice may kindly be issued. At least further proceedings till next date, madam. Or otherwise, the very purpose of filing the petition will be defeated.
No, unless and until court is satisfied that this is a case where it has to be, court feels that under 125 it cannot be done. This kind of, interim orders without a basis, that's why I believe in writing an order for an interim order also why the court is granting. It unnecessarily sets a bad precedent.
My concern is, since the matter is now posted for argument, the trial court is in a hurry to pass an order against me. In the event if court passes an order, then very purpose of filing this petition will be
What are you doing till now?
Until
No, what are you doing till now? When is this MC? I don't think MC petitions are disposed of so fast.
No, it is pending for consideration.
No.
Parallel proceedings are going on.
Not MC. In this 125, this is writ petition, IA for interim maintenance. That means you have filed in MC this IA.
No. This is a petition filed challenging the order passed by the family court in that is 125 CR proceedings.
125 CR.
Yes. Both parallel proceedings are going on, madam, before the very same court.
And even you can file an application before that court. But till such an application, this paternity is decided.
The same court which is trying both the matters, that will not say its own that proceeding. That is also difficult for me.
That also you can come up before this court. That would be the appropriate place to decide.
At least till next date, I will take emergency notice against the wife, and until then, the further proceedings. Date may kindly be fixed, madam.
Yes, whenever you want.
At 25th minute, I'll take emergency notice today itself.
But an interim order will not grant. If you want a short date, I'll give. Because you can take out notice on the hand summons.
I'll take it.
The counsel of the petition is permitted to take out hand summons on the counsel appearing to the respondent before the trial court and shall file a memo to the defect by whatever the date you say.
May I seek on the 19th?
But memo shall file a memo to the defect by 19th. List is matter on 20th.
Please.
Number 5,
Yesterday's matter.
What is yesterday's matter?
125 plus 3.
No representation for the petitioner. Counsel for the respondent is present. This is marked on 28th.
Finally.
Finally. Yes.
Serial number 29 matters. I personally submitted the counsel applied for the trial court. 50,000 has been granted as the educational expenses. However, I have mentioned as well that 50,000.
So what it should be?
I am ready to pay 50,000 matters.
For that 1,50,000 in that education expenses. Only as far as educational expenses are concerned, the court is not interfering. Don't say about 1,50,000. That 1,50,000 just related. No files.